Big Second Amendment news out of Florida with consequences far beyond one state. A Florida appellate court ruled that the state's broad ban on open carry violates the Constitution, vacated a citizen's conviction, and declared Florida Statute 790.053 out of step with the controlling standard. This is not a technical tweak. It goes to the core of what to keep and bear arms protects. And the judges answered in plain terms, open carry sits inside the text of the right. That matters because the opinion writes clearly, anchors its reasoning in recent Supreme Court cases, and tells Florida that a blanket prohibition cannot be squared with history or tradition under the modern test. People keep asking what actually changed, because Florida has long been a carry state. The answer reaches back to 1987 when lawmakers criminalized open carry almost everywhere and treated public display as a problem unless you fit narrow exceptions. Hunting and fishing trips could qualify. A brief, inadvertent display by a licensed concealed carrier might not be a crime, but it could still get you detained and forced to argue an affirmative defense later. Violation was a second-degree misdemeanor with up to 60 days in jail, a $500 fine, or both. For decades, that statute set the rules and delivered a blunt message: carry if you want, but keep it hidden. The case that pushed everything into appellate focus began on July 4th of 2022 in downtown Pensacola. A man stood at a busy intersection, greeting traffic while holding a pocket copy of the Constitution, with a holstered handgun riding inside his waistband. The firearm was visible and loaded, never brandished, and the entire interaction was recorded. He remained peaceful. Officers arrived, arrested him under 790.053, and the state pressed the charge. He moved to dismiss on constitutional grounds. The trial court refused, but certified the Second Amendment question for review, and he was convicted with the sentence stayed pending appeal. That posture forced the appellate judges to decide squarely whether Florida's categorical ban could stand. The appellate panel did not nibble around the edges. It walked through the Supreme Court's modern landmarks: Heller in 2008, McDonald in 2010, and Bruen in 2022, and applied the simple test Bruen restored, boiled down if the Constitution's text covers carrying a handgun in public. The conduct is presumed protected. If the government wants to forbid it, officials must point to a well-established American historical tradition of similar restrictions. Courts do not balance policy guesses against enumerated rights. The judges read keep and bear, took bear in its ordinary sense as carry, and concluded open carry is protected. With that threshold crossed, the burden shifted to the state to prove history allowed its ban. Florida's lawyers tried to anchor the ban in older sources and scattered enactments. The panel read the citations and found nothing resembling a flat, peaceable open carry prohibition. Some laws punished carrying with intent to terrorize the public. Some required a surety bond when a particular person posed a particular risk. Several jurisdictions restricted concealed weapons precisely because open carry remained lawful and visible. That landscape points the opposite way. 19th century cases that tolerated limits on concealed carry did so while emphasizing that open carry was the safe, lawful default. In short, history permitted regulation of dangerous people and conduct, not erasure of peaceful open carry by everyone. Context matters, because Florida was nearly alone. California and Illinois broadly disallow open carry, and Connecticut adds friction. Even Massachusetts treats open carry as legally possible. Florida's criminalization had become the outlier. The appellate court called that out, vacated the conviction, and declared the statute unconstitutional because the state failed to show any American tradition of prohibiting peaceable open carry. The opinion includes a rehearing note. But the signal is bright. The state's legal officer embraced the ruling. Agencies are taking stock, and citizens who carry have firmer ground than yesterday. The reasoning did not stop with broad declarations. The court anchored every step in the Supreme Court's modern trilogy, plus one more. Heller in 2008 spelled out that the Second Amendment protects an individual right to keep and carry weapons for confrontation, centered on self-defense, and explicitly rejected interest balancing. McDonald in 2010 incorporated that right against the states, making it binding nationwide. Bruen in 2022 finished the job by discarding the two-step scrutiny many lower courts had used and restoring a clean approach text, history, and tradition. The Florida panel quoted and applied that directive, saying the methodology is binding and cannot be avoided. They even cited Rahimi in 2024, a Supreme Court case that reaffirmed the focus on founding-era understanding, while also recognizing that Reconstruction-era sources can illuminate the scope of public carry. By walking through these authorities, the judges showed they were not improvising but following the highest court's command. The practical effect of that framework is simple but powerful. If the plain text of bear arms covers the act of wearing a handgun in public, then the activity is presumptively protected. The state must then carry the burden of proving its restriction lines up with a historic tradition. No more policy hunches, no more balancing acts. The Florida judges looked at what the government presented and asked whether any of it matched a blanket open carry prohibition. The answer was a decisive no. The state leaned on the Statute of Northampton from 1328 and related English sources. Those laws punished people who carried in a way that terrified the public, not ordinary citizens peacefully going about their business. Importing that tradition would not justify criminalizing a person who stands at an intersection calmly waving at cars. The next category was surety laws, where an individual might be required to post a bond after someone complained they were threatened. Those statutes were targeted and conditional, not blanket bans, and they still allowed carrying once the bond was posted. Florida's modern law bore no resemblance. Another group of historical references were affray laws and bans on carrying with wrongful intent. Again, the focus was on violent or terrorizing conduct, not on visible possession itself. Peaceable open carry remained lawful under those rules. The last group involved concealed carry prohibitions. Courts upheld those on the reasoning that open carry stayed available as the lawful default. Concealed weapons were seen as tools of ambush and assassination, but public carry was the transparent and acceptable mode. To use that tradition as justification for banning open carry flips the history upside down. Several key 19th century cases illustrate the point. Amate in Tennessee and Reed in Alabama, both from 1840, upheld bans on concealed weapons while warning that destroying open carry would gut the right entirely. Nunn in Georgia in 1846 and Chandler in Louisiana in 1850 echoed the same logic. The legislature could target concealed arms to deter sneak attacks, but could not deny the citizens' open or public mode of bearing arms. Even Florida's own 1867 statute reflected the same understanding. It banned concealed carry but explicitly allowed open carry outside of clothing, preserving public visibility. This internal history undermined any argument that Florida had a tradition of banning the practice. The appellate court made clear that this line of precedent leads to one conclusion. The right to bear arms includes carrying openly. The state's attempt to erase that mode exceeds its authority. Officials can regulate misuse. They can address people proven to be dangerous, but they cannot strip away peaceable open carry for all law-abiding adults. Section 790.053 failed that test, and the conviction against McDaniels collapsed with it. The tone of the opinion underscored how completely the state lost its footing. The judges described the arguments as unsupported, the analogies as unconvincing, and the historical record as leaning decisively the other way. The message is that modern fears or policy goals do not matter when the Constitution's text and tradition point elsewhere. That is what Bruen commanded, and Florida's appellate bench followed through. Observers who had doubted whether lower courts would actually enforce Bruen's strict test now have an example that the methodology carries teeth. This is not abstract theorizing. It reshapes what carrying means in one of the nation's largest states. Citizens who once risked arrest for an exposed handgun now have a ruling saying that prohibition cannot stand. Police departments that trained officers to enforce 790.053 have to reevaluate, because continuing to charge peaceful carriers invites overturned cases and civil liability. Prosecutors are on notice that history does not save the statute. Defense attorneys are already citing the opinion in other cases. The landscape of Florida firearms law looks different this week than last, and the court's reliance on Supreme Court authority makes it difficult for opponents to chip away. The judges included a procedural reminder at the close of their opinion. The ruling is not formally final until the time for rehearing expires, and the state could still try another appeal. That is routine language in appellate work. But lawyers are monitoring closely in case someone attempts to extend the fight. Even with that caveat, the signal is unmistakable. A Florida District Court of Appeal has declared the statute unconstitutional and thrown out a conviction. That reality cannot be ignored. And the effect is spreading fast. Agencies that once enforced 790.053 are pulling back. Defense attorneys are moving quickly, and the entire framework is shifting beneath everyone involved. The Attorney General responded almost immediately. The top legal officer publicly embraced the decision, saying the office supported the court. That statement gave cover to sheriffs and police chiefs, who were suddenly faced with what to do in the field. With the statute struck down, many agencies stopped treating open carry as a crime. Officers began receiving guidance to avoid arrests destined to collapse in court. Departments are already rewriting training materials, and prosecutors know charges under the old law are no longer viable. In effect, Florida's ban is unenforceable, even though the technical window for appeal remains open. For citizens, this marks a clear change. People who once feared a misdemeanor charge for an exposed handgun now have the ruling on their side. Carrying openly in public is no longer the quick path to arrest it once was. That does not mean reckless freedom. Brandishing a weapon in a threatening way is still unlawful. Using a firearm to intimidate still crosses the line. But standing calmly with a holstered sidearm is squarely protected. Those who value their rights understand the difference, and law enforcement is learning the same lesson. The opinion also points toward the future. Florida's Supreme Court could be asked to review, but it is bound by the Supreme Court's framework. The intermediate scrutiny used in the Norman case back in 2017 is obsolete under Bruen. Any further appeal would confront the same historical record, and precedent cuts strongly against the ban. That makes reversal unlikely. Lawyers still expect battles over permits, concealed carry, and the details of public possession. But the foundation has shifted. Open carry is presumptively protected in Florida, and every new challenge will start from that premise. The national implications are significant. States that maintain broad prohibitions are on notice. Courts are no longer swayed by generic arguments about modern fears. They demand historical support. And when it is missing, the law falls. Florida's experience will be cited from coast to coast. Advocates for gun rights will point to this decision as a model, while opponents scramble for distinctions. The ripple effect of Bruen continues. Reshaping firearms law statute by statute. Florida now illustrates that lower courts will enforce the method and not dilute it. The pace of change is striking. For decades, Florida's rules seemed permanent. A single man's peaceful decision to carry on Independence Day forced appellate review, and the law collapsed once scrutinized. That is how constitutional litigation works. A statute looks settled until the right challenge meets the right precedent, and then it vanishes. Citizens see why staying informed matters. The right to bear arms is not theory. It governs daily choices, police interactions, and responsibilities for anyone who carries. As the dust clears, the outcome stands as a major win for the Second Amendment in Florida. The conviction is gone, the statute is void, and open carry has been pulled into the light. Courts will continue refining the edges, but the principle is clear. Banning open carry for everyone is unconstitutional. That conclusion rests on text, history, and tradition, not shifting policy preferences. For those who waited years for clarity, the wait is over. The state tried to defend its ban with fragments of history, and the court rejected them. That is a turning point. Citizens across Florida can carry more confidently, and the rest of the country is paying attention.